Good morning. Thank you so much for joining us today. My name is Molly Ackland and I'm the new Content and Communications Manager here at MorePay, covering the lovely Hannah while she's on maternity leave. It's my pleasure to introduce the topic to you for this session, which is maternity leave regulations. So we're just going to start with a little bit of housekeeping before we start the webinar. So in terms of the agenda today, Linda will start off by running through an employee's entitlement to maternity leave and pay. She'll then move on to the importance of carrying out a health and safety risk assessment, and then we'll go through managing redundancy for employees on maternity leave. Linda will then cover the effect of a pay rise on statutory maternity pay and the payment of bonuses whilst an employee is on maternity leave. And then finally, she'll discuss common pitfalls and how to avoid them before we move into the Q&A section. So how to ask a question. After the main presentation, we will move into the Q&A section of the webinar. So you might have noticed that your microphone is on mute, but we do want to hear from you. So please drop your questions into the question panel shown here. We've had a really incredible response to this webinar, so I imagine we'll have lots of questions, but Linda will do her best to get through as many as she can at the end of the session. And on another note, if you are facing any technical difficulties, then please don't worry too much. We'll be sending everyone a recording after the session. However, if you are facing technical difficulties, please do flag it in the question panel, because if lots of them come flooding through, then I'll know that there's an issue on our end, and I'll do my best to fix it. So before I hand over to Linda, I'm conscious that we have a few people on the webinar that aren't familiar with MorePay. So I'm just going to give a really brief introduction. So we provide payroll and HR software as well as outsourcing services to UK businesses. We've been around since 1966 and we have all the accreditations that you'd expect, and we're rated excellent on Trustpilot. Our promise is to make payroll and HR easy, and here's how we do it. So we've built payroll and HR software that's easy. We deliver quality outsourcing options, and all of this means worry-free compliance for businesses. On this slide that you can see some of the businesses who trust us to take care of their payroll and HR. So that's enough about us. Let's meet today's presenter. I'll start by introducing you to Linda, who you may recognise if you've attended some of our webinars in the past. Linda is our HR advice line manager and has been with MorePay since 2010. She is CIPD qualified with over 20 years of experience, and Linda is responsible for managing the HR advice line team, which operates 24/7, 365 days a year, to provide our HR services customers with around-the-clock support. Good morning, Linda. I will now hand over to yourself to get started on today's webinar.
Morning, everyone. Thanks for attending. Thanks, Molly, for the introduction. Yeah, we're going to cover maternity quite in depth today, so bear with us because it's a bit of a meaty subject, and I've got to say one of my favourites, so I could talk all day on this. So if we want to first start with maternity leave and eligibility and entitlement, if we just move on. Yeah. Okay, so believe it or not, it's a day one right. So everyone who starts a job that's pregnant and they're an employee are entitled to maternity leave. People think that they may not be entitled to it, but everyone is entitled to maternity leave. Every employee is entitled to maternity leave. We need someone to give us evidence of this. So ideally, we would get what they call the EWC, the expected week of childbirth. That would come from the employee's midwife, generally around the 20-week mark. When you've had the second scan, the employee will get a MAP-B1. Now, they don't automatically get this, which is surprising because most people need it, and they have to request it. So if we just give our employee a nudge in the right direction to request it around the second scan time. They also to be entitled to maternity leave have to apply for it. So they have to tell you the date when they want to go on maternity leave. You know, some people leave it late, some people want to go early. So it's great that they you know, put that in writing to you so you can process it formally. It doesn't have to be in writing, but if your policies or procedures request it in writing, then the employee should comply with that. We can require them to put it in writing, but legally there's no obligation to put it in writing. Now, this needs to come through by what they call the EWC, by 15 weeks before the EWC, which is called the qualifying week. So roughly that's when the employee is about 26 weeks pregnant. They should have already decided when they want to go on maternity leave. Now, that's not always possible and might be surprising for some people to hear, especially if they've already had a baby, but some people don't actually know they're pregnant till quite late on. So in that case, we just need it as soon as possible, really, because we can't rely on this 26-week application if they didn't actually know they're pregnant. Also, some people do struggle to get, maybe they forget to get the MAP-B1 from the midwife at the particular appointment where they should have asked for it. So we would be flexible and allow them to get it at the next appointment. So it doesn't mean that they're not going to be able to get the maternity leave. It just means that we just give them a nudge in the right direction. Okay, so once we're aware of the pregnancy, the employer has an obligation to do a health and safety risk assessment, and that's to protect the mother and the unborn child. So that's expected to be done as soon as we reasonably know she's pregnant. Some people will tell us quite early on because maybe they're in a high-risk job. Some people might not want to do it until after the first week scan, and maybe the job is more of a desk-based, lower-risk job. Depends on what type of environment you work in. If you're not quite sure, just give us a ring on the advice line and we'll go through it in more detail. If we move on. Okay, so eligibility and entitlement. So like I said, it needs to be an employer, not a worker. Worker isn't necessarily entitled to maternity leave, surprisingly enough. But if it's an employee, it's a day one right, and we need to give the correct notice. The entitlement of maternity leave is 52 weeks. And if an employee doesn't tell us they're taking the 52 weeks, we would generally assume they are until they tell us something different. So that 52 weeks is broken down into two sections, well, three actually, but two formal sections of 26 weeks ordinary leave and 26 weeks additional maternity leave. And I'll cover the reason for that in a further slide. But it's broken down into these two distinct sections. There is also something that we need to consider, which is compulsory maternity leave, which protects the employee for the first 2 weeks after the baby's birth. So this is a compulsory element of maternity leave. So even if your employee doesn't want to take time off legally, they need to take them first 2 weeks after the baby's birth. Now, if you work in a factory environment, that 2 weeks increases to 4 weeks. So the employee must take at least 4 weeks off after giving birth. So yeah, it's important just to consider that when the employee is asking for their maternity leave. So what you've got to consider is that you've got to confirm that maternity leave in writing to the employee. That is your legal obligation. You've got two main legal obligations. One's to do the health and safety risk assessment. The other one is to confirm the start and the end date of the maternity leave in writing. We do have templates for all this on the advice line. So if you've got somebody that's going on maternity leave soon, just come to us and we'll discuss it and provide the right templates. So we get this quite often, a question, it's when can I go on maternity leave? Maybe somebody's struggling with a pregnancy and they want to go off early. The earliest they can take the maternity leave is 11 weeks before the expected week of childbirth, the EWC. So we'd get the expected week of childbirth on the MAP-B1, we'd count back 11 weeks, and that would be the first date they can actually take their maternity leave. So yeah, some people like to push it out as long as possible and stay in work as long as possible. But if somebody said, I don't want to go on my maternity leave until the baby's due, and they go off sick due to a maternity related illness, an employer can start the maternity leave at the 36-week point. So when they've got 4 weeks before the EWC, the expected week of childbirth. Okay, if we move on. So we're just going to cover pay now. So this is a bit complicated, and I'm sure when it comes to it, your payroll department will support you with it, but this is the basic overview of entitlement. So to qualify for statutory maternity pay, an employee must earn on average £123 per week. That's called the lower earnings limit. So this employee needs to be employed as well. It's a bit of a complex calculation, which I'm going to simplify it for you. Basically, if they are pregnant when they start working for you, it's unlikely that they will get maternity pay. If they are pregnant after they start working for you, then it's likely. There's a specific calculation and it gives you about a week of question marks. So unless it's really a tight calculation, that would generally be the rule of thumb. But the legal definition is that we get the expected week of childbirth from the MAP-B1, we count back 15 weeks, and that gives us a qualifying week. So in that qualifying week, the employee has to be employed by you to be entitled, sorry, not in the qualifying week, sorry, it's 26 weeks at the qualifying week. So we go back from the expected week of childbirth, 15 weeks, and then go back 26 weeks. And then at that point, they would have had to have been employed by you to qualify for maternity pay. And they would also need to earn an average of £123 per week in the 8 weeks or the 2 months prior to the qualifying week to be entitled to maternity pay. Like I say, your payroll department should work it out for you, but as long as they're earning over the lower earnings limit and they're employed ideally before they're pregnant, they would generally be entitled to some element of maternity pay. They would also need to provide evidence of their pregnancy. Now, I've put in provide a MAP-B1 form, but like I say, sometimes in some strange, unfortunate circumstances, people give birth and they don't know they're giving birth. And in that case, all we would require is proof of birth. Could be a birth certificate, something from the GP, just something that medically proves that they've given birth. But ideally, it would be a MAP-B1. So statutory maternity pay, so it's not paid for the full 52 weeks, it's paid for 39 weeks, and that's broken up into two elements. The first element is it's 90% of the employee's average weekly earnings. Now that's before tax and including any bonuses or any other payments they got during the qualifying period. So if you remember, we talked about getting to the qualifying week and looking at the 8 weeks before that, or the 2 months pay before that if you're monthly paid, or however the regularity is, as long as it's roughly the 8 weeks before that, that would give us the average weekly earnings in that time. So if they've got any overtime, any bonuses, it's taken from the gross pay, and that would all be included in this 90%. So you get 6 weeks at 90% of the average weekly earnings, and that's before tax. The remaining 33 weeks are at the current SMP rate, which has recently gone up to £184.03, or it's 90% of the average earnings if the employee earns less than that. So it is a bit of a complicated calculation. Like I say, your payroll department should work that out for you. We can guide you through it as well if you give us a call. But yeah, that's the basic entitlement. Now, if the employee doesn't qualify for any of this, then what we have to do legally as an employer is issue what they call an SMP1 form, and we would then take a copy of the MAP-B1, we would keep the copy for ourselves, and we would have to give the original back to the employee with the form so that they could go and claim maternity allowance from the government. We don't pay as an employer maternity allowance, we only pay maternity pay if they're entitled to it. So if somebody's already pregnant and come working for you, or they don't earn over the lower earnings limit in the 8 weeks prior to the qualifying week, then they would get an SMP1 form and take that to the government and claim the money from them. Okay, if we move on. Okay, so the health and safety risk assessment. So once we're aware of the pregnancy, like I say, we should be doing a health and safety risk assessment, and that's protect the mother and the baby. Now, this is law. It's not something that is nice to have. It didn't used to be law. It was only guidance, but It has now been, it's been enshrined in law, so it is a legal obligation. You must make sure that you repeat this risk assessment as the pregnancy progresses, because the employee is likely to change, the requirements likely to change as they progress through their pregnancy. So I would check in with the employee at least 2 or 3 times during the pregnancy to make sure that the risk assessment that you have on file is still valid. It's quite a complex thing, and we do have a basic template, even though it's a health and safety issue. But we need to make sure that that risk assessment is relevant to the job as well. So we do have a health and safety team that can support you with that if our basic risk assessment doesn't cover the, maybe you've got a more complex role, maybe you work in manufacturing, chemicals, something that poses more of a risk to the employee. In that case, we would, you probably would need to look at getting a more in-depth risk assessment developed for your business, specific to the work that the individual does. And this risk assessment doesn't just end when the employee goes on maternity leave. When they return, if they're breastfeeding, we should still continue with the risk assessment, or just the fact that they've given birth, we need to be careful, because you know, there are medical things that have gone on, and there's quite a big risk to the employee on maternity work, especially if they work in a heavy lifting manufacturing environment. Okay, moving on. Okay, so this is just going on about the significance of the risk assessment. So it's worth noting that not all risks are, you know, things that you would always consider. So, you know, standing on your feet too long could be a risk. You know, not having a break during the day, maybe only having your 20 minutes unpaid meal break in an 8-hour shift, that would be a risk to a pregnant worker. Like I said, we need to revisit and review the risk assessments to make sure that they are valid throughout the entire pregnancy and when the employee returns from maternity leave. We should ensure that they've got access to the health and safety advice. Most companies will have a health and safety officer. If you don't have one, I would strongly encourage you do have one, and maybe you look to get some support from we do have a health and safety service. And yeah, it's quite important that if we do breach any health and safety obligations, it's not just a tribunal we would be facing, it's potential criminal acts, and that could lead up to 2 years in prison, unlimited fines for the company. Health and safety, we don't mess with it. It's a very, very serious thing that we need to consider. So if there is a risk, what do we do? What do we do if we have a chemical plant where the employee is at risk? We look to adjust the working conditions if we can. If we can, we need to find them alternative work. Maybe, you know, the employee is a waitress that, you know, is on her feet all day, lifting heavy loads, taking plates. We'd look to maybe think, can we move them to a cloakroom job where they can sit down? You know, if they're office staff and they're sat down all day, we would tell them to take, you know, breaks, regular breaks, move away from the workstation, do something that doesn't mean that you're just going to be sat in the same place all day. So we would do our best to try and find safe work for the employee during their pregnancy. Even getting people to do filing, I don't know, we would look for every opportunity to get them to do something useful for the business during the pregnancy. And if there isn't anything we can find them to do during this time, then we've got legal obligations to pay them full, and we'll put them on suspension. So then they would be on full pay for the remainder of their pregnancy. So yeah, it's in your interest to find something that the employee can do. If you've got a situation and you're not sure, give us a call and we'll try and support you through the process as best we can, making suggestions to try and help you support your your employee through this process. Okay, next slide. Okay, so this is probably a subject that most of you have logged on for today. It's the redundancy maternity leave. There are recent changes from April this year. And so there was a new act that came in on the 6th of April. Before this, there was some support given to employees on maternity leave, but they have been further enshrined in law and extended so that an employee is further protected from being made redundant during their pregnancy, during their maternity leave, and on return from maternity leave. So what this actually means is that people have 18-month protection after the birth of the baby from being made redundant. Doesn't mean you can't make them redundant. It just means that they have what we have called in the past the golden ticket. So if you've got a pill redundancy situation, you've got somebody that's just returned from maternity leave and other employees, the employee who is within that 18-month period should be offered the job over the other employees. It's very similar to what was in place before. It is just an extended right that goes on for a longer period of time. So yeah, and the same goes for adoption leave. The same rights apply. So the 18 months will be in place from the moment of placement. So if an employee has had adoption leave returned, they are protected for an 18-month period and should be offered a role above other employees. Employees taking less than 6 weeks shared parental leave will have protection during the leave. However, employees taking more than 6 weeks will be protected again from the 18 months after the birth. So if your birth employee has transferred their leave over to the non-birth employee, or maybe you only employ the non-birth employee, if they take more than 6 weeks off after the birth, they will also have that protection. So it's worth noting that, because we wouldn't always think of the non-birth partner as having that protection, but that is the case with the new legislation. Okay, moving on. Okay, so how would we manage the redundancy? We would consult the same as we would normally. We would invite the employees on maternity leave into meetings. We would give them the opportunity to fully participate in the process, and they shouldn't suffer a detriment for being off on maternity leave. Again, as I've said, the suitable alternative employment should be offered to the person who has the protection if there is suitable alternative employment. As per my previous conversation, it's the golden ticket rule is what we call it. And yeah, it gives that extended protection over being made redundant. Okay, so how does a pay rise during your maternity leave affect the business? If you just flip on. Okay, so this case is quite an old case now, but it's something that most HR professionals, payroll professionals should be aware of. It's the Alabaster versus Barclays Bank case, where SMP is based on the average earnings during the eight-week reference period before the qualifying week, which if you remember, the qualifying week is 15 weeks back before the expected week of childbirth. So during that time, we've worked out that 90% calculation, or if your employee earns less than that, their entire reference period might be affected. If you're not sure on the detail, give us a call, we'll talk through in more detail. So if somebody gets a pay rise during their entire statutory maternity leave, what we would have to revisit is the SMP calculation, and we would then need to top up either the 6 weeks of 90% taking into account the new pay rise, or if they are earning over the low earnings limit, which is, if you remember, £123, but less than the statutory maternity pay, we may have to revisit the entire 90%. But for the majority of employees, it will only affect the 6 weeks of the 90% pay. Also, it should also be applied to the 2 weeks compulsory leave, or 4 weeks if it's not the 6 weeks 90%. So it's a bit of a tricky calculation. If you're not sure, your payroll company should work it out for you. I know before my life working at MorePay, I used to use MorePay for my maternity calculations, and I had a lovely advisor who used to work it out for me and then tell me the top-up payments that needed to be made. So hopefully your payroll department will do the same thing for you. Okay, so how does it affect any enhanced maternity pay? Maybe you're a company that do pay more than the statutory minimum. It's a tricky area. Basically, depends what your contract says in effect, but it would be best practice to recalculate a contractual maternity pay, but not always legal. If you've got a case where you do give contractual maternity pay and it's based on your own calculations, give us a call, we'll look at your policy, look at what you say and talk you through the best way to deal with it. But as it stands, there's no legal obligation to, no basic legal obligation to readjust contractual maternity pay. It may be something you do give right to in your policy, so take advice. So this is another grey area that does come up quite a lot. It's quite an interesting area. So what if your company pay bonuses? So if a bonus constitutes remuneration, the employer will not be obliged to pay it to the employee when they're off on maternity leave. However, if it's a contractual benefit, you will have to pay it despite them being on maternity leave. If the employee goes on maternity leave partway through the bonus year, which can happen, we would advise that you prorata the payments. So employees should not suffer a detriment, should be paid for the time that they were entitled to it before they went off on maternity leave. Or if it's a bonus that everyone gets despite any input, if it's not individually linked to their performance or their contribution, then it should be paid in full for the time they're off. So if we're prorating, we should calculate the time before they went on maternity leave, and we should also include the 2 weeks compulsory maternity leave if they work in an office or any non-factory environment. If they work in a factory environment, then it will be the 4 weeks. We would also look at the time when they've given birth. So if they've returned to work mid-year, we would also look at prorating that. So discretionary bonuses, there's no obligation for an employer to make the payment, but it is difficult to actually pinpoint that and to work out whether they should have got the discretionary bonus. So what I would say is that legally, the law does say there's no entitlement, but it can be complex, and make sure you take advice based on your policy and the reason you don't wish to pay it. It could become a bit of a problem. So if you take advice, then that will be the best thing. Make sure we're giving the right support and advice. Okay, so we're going to cover off kit days now. So this is, okay, we're going to cover antenatal appointments. So an employee, from the moment they are pregnant, are entitled to time off with full pay for antenatal or pregnancy-related appointments. It starts from the first day of employment if they are an employee, and whether they work full or part-time. We cannot require them take the appointments, and it can be tricky for employers, but it is our legal obligation to so these antenatal appointments have to be on the advice of a medical professional, and they can include, but are not limited to, scans, health checks, and parent craft and relaxation classes. If an employee is getting advice to go and have some, maybe, I know people that have had acupuncture because of the pregnancy related sickness, that would then be considered a paid appointment. So it's not just the basic appointments that you would normally expect them to go and see the midwife. It could be other things connected to the pregnancy. Okay, moving on. The kit days and reasonable contact. So employees can work up to 10 days during the maternity leave. If they transfer over to shared parental leave, then that will stop, and then the shared parental leave contact days would kick in. But during maternity leave, there are up to 10 days that an employee can work, and we call them kit days, keeping in touch days. Now, they're optional. An employee cannot say, I am working 10 days if you don't need them. Maybe you've got somebody covering them, you can't afford the expense of paying your lady off on maternity leave or person off on maternity leave, and the individual covering them. So it's got to be agreed between both parties. And we would also agree what type of work they're going to do when they have a kit day. So you would have a call with your employee, discuss if they want to come in on a kit day, talk about whether you're required to come in maybe just for a meeting, which could be an hour, maybe it's a full day, whatever it is, however many hours it is during that day. So it could be 1, it could be a full 7.5, could be 12 if you do 12-hour shifts. Whatever that is, that would count as a full kit day. So it would tick off one of the 10. In the same vein that you can't be obliged to have an employee on a kit day, we cannot force an employee to come in on a kit day as well. So it's got to be an agreement with both parties. And the legal right to maternity pay isn't affected by having a kit day. What we would do though is they wouldn't get paid their statutory maternity pay and a full day's pay. The two would generally be offset, but that's something you would agree with your employee when you set up a kit day. So some employers don't actually pay for kit days. What they do is agree a day in lieu when they come back to work. It's whatever's in your policy or whatever you agree with the employee beforehand. Now, reasonable contact. So what does that look like? We shouldn't forget people that are on maternity leave, and we wouldn't consider they don't want to be bothered with work. They're off, with this beautiful little bundle that they've just had, and they're not going to want to be bothered with work. That's really, really wrong to assume. We should always communicate with staff going on maternity leave. If you can agree that up front, that's brilliant, because then you get a good idea of when an employee would want to speak to you. But you also may have to speak to them about important business changes. So, it's really important that you keep them lines of communication open during maternity leave. And also remember to invite them to, the big company announcements. We colleague connect days, anything that's quite important to the business and the employee would want to be there, then they should be invited to. But remember, we can't compel them to attend. We should invite them to it. And these include nice things like the Christmas parties, summer parties, team days out, anything where if the employee was in work, they would have been invited. They should still be invited when they're off on maternity leave. We should also ensure that they are fully informed with any changes to the team, any promotions, any current vacancies in the team. Otherwise, we risk a discrimination or a constructive dismissal claim if we don't. So it's really important that that they are fully aware of what's going on in the department, in the team, and in the business. And a kit day can be used to cover this. So say you've got some really important technology being brought in and you've got trainers coming in on a particular day to train all the team on the new equipment. It's really useful to offer the employee a kit day so that they are fully included, fully communicated and fully trained as well. So yeah, it's really important that we keep that level of contact with our maternity leavers and maternity people while they're off. We also can consider disciplinary action. This is generally in extreme circumstances. I've been in this role now probably about 13.5 years. And in my time, I've only actually disciplined 2 people while they're off on, not personally, but advised on it, 2 people while they're off on maternity leave. But it does happen, you know, you've had somebody that's heavily pregnant that you've just found out they've been fraudulently siphoning money off the business, you know, before they went off on maternity leave. That needs to be addressed, can be addressed through kit days. But you may want an employee to comply with the process, but we can't compel them to if they're on maternity leave. It's a very tricky situation and shouldn't be connected to the pregnancy. It should be something to do with, you know, anything outside of the pregnancy. Like I say, I think I had a case where somebody was fraudulently siphoning money off and they went on for maternity leave, and we utilised kit days and managed them out of the business because they've been stealing from the company. So there are extreme cases where it can happen. Hopefully it won't happen to any of you guys. So annual leave, this is a big topic that people generally misunderstand. So I love covering it because it can be a bit of an eye-opener. So an employee still accrues annual leave while they're off on maternity leave. So they can, you know, go off on maternity leave halfway through the year, I've only taken so much, return halfway through the next year, and have them 2 full entitlements open to them. So what I would recommend is that you sit down with your employee before the maternity leave, talk about their entitlements, talk about how many days you want them to take off before they go on maternity leave, and if their maternity straddles holiday years, talk about any holidays that you may want them to take before they return from maternity leave. So we can agree holidays up front prior to them going off on maternity leave, an appropriate amount. We can also agree that they tag a certain amount on at the end of the maternity leave. Lots of employees want to take holidays in the unpaid period. If you remember, maternity leave is 52 weeks. You only get paid for 39 of them weeks. So some people would want to take an element of paid holiday during that unpaid period. Alternatively, people may want to take the full 52 weeks, including the unpaid period, and tag the holidays on at the end, which would then extend the maternity leave. So yeah, I would generally say, an employee is going off in February. I personally wouldn't really want one of my employees to take all of their maternity leave for that year prior to going off. But then we'd also want them to take a good chunk of it. So just be wise with when they're going off, when your holiday year runs from, and you wouldn't want, heaven forbid, somebody goes off in February, they've taken all the maternity leave, the worst thing happens, and they want to come back to work maybe in May, and they return to work and they've got no holiday entitlement because they already took it prior to going off. That is something, and it's awful to even think about, but it's something that we as employers should consider. So maybe we take an appropriate number, but not all. Manage each case on its own merits, and if you're not sure, take advice. Okay, so rights on returning to work. Now, if you remember from earlier on in the webinar, we talked about the maternity leave being separated into 2 sections, which is ordinary maternity leave, that's the first 26 weeks, and then I think there's a typo here. Sorry guys, I missed this. It's the last 26 weeks of maternity leave is additional. Sorry, the last 26 weeks is additional maternity leave. So yeah, it is not 26 and 36 weeks as it says here. It's 26 and 26, and total of 52 weeks. So an employee who returns to work before the last day of ordinary maternity leave has the right to return to the same job on the same terms and conditions as if they'd not been away from work. An employee who returns in the second part of the maternity leave, the additional maternity leave, and or who has taken at least 4 weeks off in parental leave on top of their ordinary maternity leave, so they would have taken the 26 weeks and maybe 4 weeks of parental leave, shared parental leave on top of their OML, ordinary maternity leave. is entitled to return to the same job unless it's no longer reasonably practicable. Now, what does that mean? That's a tricky thing to define, and it would have to be something significant. Take advice. Generally, somebody will have the right to return to their job. If you don't think that's the case, give us a call. We'll talk through it in detail, and we'll make sure that you're doing the right thing. You don't risk a claim. If we agree that that is reasonable, that they go to a different job, the employee is entitled to return to a different job, but it's got to be suitable and it's got to be appropriate, and the terms and conditions should be equal to the terms and conditions. The term is no less favourable, so we need to make sure that they're not suffering a detriment as a result of going on maternity leave, but take advice. And as per any other process, when we are talking about changes to contracts or redundancies, consult with the employer on any changes as soon as you can. So the term is as soon as reasonably practicable to do so, which in reality is just as soon as you reasonably know, and we can speak to the employee potentially through a kit day as discussed in the last slide. Okay, so we're now at the Q&A, so feel free to ask as many questions. I'm happy to help.
Brilliant. That was really, really interesting. Thank you, Linda. We're just filtering through some questions. We've got quite a few that have come in already. So just bear with me a moment. Okay, we've got a question here for you, Linda, regarding SMP. So this person said, thank you so much for the important insights, and she's got a query regarding SMP. So the question is a member of staff that they have sponsored for eligible for SMP under the circumstances she is 14 weeks pregnant, yet to receive her MAT B1? She's resigned and her last date is the 31st of August. Her due date is in November, and she is leaving the UK in the first week of August. So if, sorry.
So I can pick that up from what you've just said. So basically, for an employee to be entitled to maternity pay, they have to have been employed by you before they were pregnant. So, and there's like a week calculation, but if we say a week before they were pregnant, it is more definitive, so we'd need the exact dates to work it out. But if they're employed by you before they were pregnant and they are still working for you in the qualifying week, which is, if they haven't got a MAT B1, but we can roughly calculate it from the expected week of childbirth. So does the employee have the expected week of childbirth? Will give us a basic idea, but they would need the MAT B1 to get the maternity pay anyway. We need evidence of the pregnancy. So we would count back from their expected week of childbirth, count back 15 weeks. And if they were employed at that point, that's called the qualifying week. If they were employed at that point and earning over the low earnings limit and employed before they were pregnant, then it would be likely they would still be entitled to statutory maternity pay. So we need the expected week of childbirth, count back 15 weeks, look at the average earnings in the 8 weeks or the 2 months before that, and also note that they were employed before that, the pregnancy. It would be highly likely that they're entitled to it. So they need to be employed on that magic day and earn over the lower earnings limit in them 8 weeks before the qualifying week. Your payroll department should work it out for you. There is also a really useful calculator on the direct.gov website that if you've got all the pertinent dates and the average weekly earnings, a rough average weekly earnings, because we might not be at the qualifying week yet, it may tell you already whether it's likely that she would be entitled to maternity pay. An employee doesn't need to be employed by you to be entitled to maternity pay. So as long as they meet all that qualification, if you dismiss them or they resign before they go off on maternity leave, unless they're taking another job, they may still be entitled to maternity pay from you.
Great, thank you, Linda. Got a slightly shorter question here, which is it a legal requirement to have a maternity policy?
No, it's just good practice. Our standard documentation talks about maternity. It is good practice to have a plan, have a policy, know how to treat people, for people to know what they're entitled to. Communication's key with any relationship, including point when people are going off on maternity leave. So we'd always want something in writing. There's nowhere in the law that says you must have a maternity policy, but you do need to be reasonable. We need to be a reasonable employer. We need to set out our expectations of the employee, as well as their expectations of us. What are we going to do? We should tell them what we're going to do. They should know what they are required to do, to avoid any confusion.
Thank you. Another one here. What is your promotion entitlement during maternity leave?
So you don't have to be promoted. What you have to be is made aware of the possibility of the promotion. So if you've got a vacancy that, well, not even that you think that the employees should be informed of vacancies in the business while they're off, whether you've got a newsletter that details that, make sure that the employees on the distribution list with the personal email address, if it's something that affects their team, then they should be let know basically the same time as everyone else. It shouldn't. There was a big case, I can't remember the detail of it off the top of my head now, but there was a big case a few years ago where an employee wasn't told about a vacancy at the same time as everyone else. So they were made aware of it a week later, and that led to quite a large payment in tribunal, because they weren't let know and therefore didn't have the same time, the same energy to prepare for it as everyone else. So it's not that they are entitled to have the promotion, it's they should be communicated with about the promotion, and they shouldn't suffer a detriment as a result of being off on maternity leave.
We've got one here regarding kit days. So what are the general rules about payments? So if someone came in for, let's say, an hour meeting, would you pay them for a half day as opposed to a full day? How would you kind of work out the payment there?
So this is a bit of a grey area, and we would want a policy that says what you're going to do, or an agreement with the employee. It would be good practice, not necessarily legally required, to pay them a day's pay if they have a kit day, because if you require them to only work an hour, but they could have been required to work a full day and we're only paying them for an hour, then if that's because of our requirements rather than their availability, that might be unreasonable. So there's no hard and fast rule. It's what's agreed with the employee. So they just shouldn't suffer a detriment as a result of being off on maternity leave, but it does take a full day off them, if you like, from an entitlement perspective. So I would generally advise a full day, but if something that the business couldn't afford, maybe you could look at doing something else, a different arrangement. So agree with the employee that maybe they get a full day in lieu when they come back from the maternity leave. so like a free day off, and where they would get their full pay as normal. But if not, it's generally advisable to pay them a full day, not strictly legally required. It's a very grey area. Take advice.
Thanks, Linda. I think we've got time for a couple more questions. So we've got one here. An employee has decided to change their return date. So how much notice must they give the employer? And can the employer refuse this date if they have a valid reason?
So as long the most important thing in this case is that the employer has confirmed the maternity start and return date in writing. So if that date is confirmed with the employee in writing, we've got evidence of that, confident that's been issued, and the employee wants to bring that date forward, then they should give 8 weeks notice for that. Now, if they want to delay that date and it's still within the 52-week period, so they're still within their maternity period, then that becomes a bit more difficult because, you know, ultimately people only need to give us reasonable notice if they want to change their maternity start date. So in this case, it would be reasonable to allow it if they want to take more time off and they're still within their 52 weeks. If they want to bring their date forward, they need to give you 8 weeks notice in writing. And you can, you know, enforce that, maybe because you've already got somebody agreed to cover their role during that period, therefore it's going to be an additional cost to the business. Like I say, take advice on the individual circumstances, but if they want to bring it forward, as long as they've given 8 weeks, that's fine. If they want to extend it and they've given us a reasonable amount of notice, that is advisable. Take advice if you don't want to do that on the particular case, and we'll go through it in more detail.
Another one here, if an employee on maternity leave wants to put through a flexible working request, so for example, to reduce their hours when they return, is this allowed? And are there any extra considerations which the employer needs to think about?
So sorry, just tell me the start of that again.
Sorry. If an employee on maternity leave wants to put through a flexible working request to reduce their hours when they return, is this allowed? And are there any extra considerations which the employer needs to think about?
The answer is yes and yes. So they can, and we should consider it. Flexible working is a whole different minefield in itself, and an employee can, while on maternity leave, apply for flexible working on return. And with the new flexible working guidance, you know, we have to consult with the employee, and they no longer have to legally describe how that's going to affect the business. That's the change from the employee's perspective. We have to consult with them as an employer, so bring them in for a consultation meeting. So that would be a kit day to still off on maternity leave, and discuss it with the employee. So if we want to reject it, if it's unreasonable, then there are fair reasons for rejection, and we can potentially reject it. We need to be careful. There's quite a big case a couple of years ago with an estate agent who was refused a flexible working request because she wanted to drop her child off at nursery, so she wanted to reduce her hours slightly, and it was rejected, and she had a massive payout in tribunal because it wasn't reasonable to reject her request in the circumstances. So it would depend on the application, depend on what the employee wants, depending on the role and the obligations of the role. We can always reject it, but we don't always have to accept it either. Potentially fair reasons for rejection. Take advice.
Thank you, Linda. We've just got one more to squeeze in, hopefully, before we wrap up. So we spoke about antenatal appointments earlier. So if someone requires time off for mental health appointments related to their pregnancy, is this then covered under the antenatal appointments?
I think the important part there is that it's related to the pregnancy. If it was mental health appointments, then there would be a different set of circumstances to consider, but not necessarily the maternity question. So if it's connected to the pregnancy in whatever way, then, and it's medically advised, then they would be entitled to paid time off to attend. If it's not connected to the pregnancy, it's not pregnancy related in any way, but it's a disability and it's time off to help manage that disability, that's a grey area. And there is some legislation that says it should be paid, and there is differing guidance on it. It's a grey area in itself, but if it's connected to a pregnancy, then it's quite clear that they're entitled to paid time off.
Thank you so much, Linda. That's really helpful. Thank you. So before, we're just going to go on to wrapping up the session, but before we do that, I'd just like to point you all in the direction of our Knowledge Centre. It's really easy to find in the menu of our website, and it's packed with lots of helpful resources, including upcoming webinars, guides and blogs, and plus everything is free to download. Just to let you know as well, there was a lot of questions in the Q&A there regarding maternity pay. We are actually doing a webinar on the 5th of June, and that is all about maternity pay regulations. So please look out for that one and sign up, because I'm sure a lot of your questions will be answered in that webinar itself. And finally, if you'd like to find out a little bit more about our HR and employment law services, please drop a message into the Q&A panel and one of my colleagues will get in contact with you. Our HR advice line runs 24/7, 365 days a year. So no matter when any HR issue crops up, best practice employment law advice is always available over the phone, anytime, and delivered by a highly experienced team of qualified experts. And before we close off today, you will see a prompt to fill out a poll when we close the webinar. So we're just looking for some opinions and insights here to help us tailor our research, resources and content for our listeners and readers. So if you have got a few seconds at the end to complete that poll, then we'd really appreciate it. So that's everything from us today. Everyone who's attended will receive a recording of the webinar and a copy of the slides as well. Thank you so much, Linda, for hosting today. You've been fantastic as always. And thank you to everyone who joined. I hope you found this session really useful, and I hope you have a lovely day. I will now close the webinar. Thank you.